Today, we begin in the middle of a moment many applicants never anticipated. A rule change that ICE had resisted, lawyers had demanded, and families had prayed for. A sudden announcement. A bright spotlight on mobile patrol units. A Democratic proposal using words that sound protective, but aren't guaranteed. This proposal didn't unfold over years. It unfolded in 3 weeks. 3 weeks that could eliminate roving enforcement. 3 weeks that could require judicial warrants. 3 weeks that could change how ICE conducts sweeps, or change nothing at all. One wrong interpretation here, and you could open your door to agents who shouldn't be there tomorrow. What Democrats proposed crossed a line that ICE hoped would never be drawn. And when that line was introduced as legislation, enforcement advocates did not hesitate. They responded with opposition, lobbying, and warnings so aggressive they revealed exactly what ICE fears losing. Most people celebrate proposed reforms. They make the same mistake. They fall straight into the trap. But today, you're going to do something different. For 2 months now, there had been signals, not from official reform announcements, not from DHS policy reviews, just signals, that Democratic legislators were preparing something unprecedented. Democrats have been critical, yes, but also increasingly specific in that approach. Their proposals followed a pattern, a strategy, almost a blueprint. But what triggered panic among immigration applicants this week was that the pattern suddenly became legislation. Experts who monitor congressional immigration reform recognize the indicators. The specific targeting of mobile patrols, the warrant requirement language, the elimination of workplace sweeps without court orders, the sudden bipartisan interest. And when Democrats introduce enforcement restrictions, ICE mobilizes its entire political apparatus to kill them. Policy analysts noticed something else. The proposals being circulated weren't just about limiting authority. They were about requiring accountability. They were about making ICE operate like every other law enforcement agency, with warrants, with judicial oversight, with consequences for violations. For immigrant families living in fear of random enforcement, this sounded like salvation. For people detained during warrantless sweeps, this sounded like justice. For communities where ICE operates with unchecked authority, this sounded like basic constitutional protection. But proposals aren't law. And the distance between proposal and implementation is where hope goes to die. Early Monday morning, congressional staffers detected what they described as comprehensive reform language, including warrant requirements for immigration enforcement not proposed in over 2 decades. They understood something crucial. These reforms would fundamentally change enforcement, and ICE would fight them with everything. The warning issued by immigration attorneys after this proposal was not optimistic. It was not celebratory. It was cautious. Advocate after advocate described the reform proposals as necessary, constitutional, and most importantly, unlikely to pass without massive public pressure. But proposals only become law if legislators face political consequences for opposing them. ICE is already lobbying against these restrictions. Law enforcement unions are calling them dangerous. Republicans are framing them as open borders policies. And when enforcement agencies mobilize politically, reform becomes nearly impossible. Today, Democratic sources confirmed that proposed legislation would eliminate ICE mobile patrols targeting immigrant communities, including roving operations that had recently been expanded for what reformers believe are constitutionally questionable sweeps. They drafted language before ICE could mount full opposition. They targeted mobile units that conduct warrantless stops. They proposed warrant requirements for home enforcement. They demanded judicial oversight before workplace operations. This wasn't symbolic reform. It was operational transformation. And that's what made ICE's reaction so fierce. Because when you require warrants for immigration enforcement, you can't conduct mass sweeps. You can't operate mobile patrols that stop people based on appearance. You can't raid homes at dawn without judicial authorization. You can't detain workers without specific criminal warrants. Everything that makes ICE's current operations efficient becomes illegal. And efficiency built on constitutional violations isn't efficiency. It's abuse. Inside ICE field offices, the panic is real. Officers are being told these reforms would cripple enforcement, that requiring warrants means criminals escape, that eliminating mobile patrols means losing operational flexibility, that judicial oversight means deportations slow to nothing. But here's what they're not saying. Every other law enforcement agency operates under these exact restrictions. Police need warrants for home searches. FBI needs judicial authorization for arrests. ATF can't conduct roving patrols stopping people randomly. ICE is the only federal law enforcement agency that operates with nearly unchecked authority. And they claim they can't function without it. That claim is revealing, because what it actually means is they can't generate current deportation numbers without constitutional violations. They can't conduct workplace raids without violating warrant requirements. They can't run mobile patrols without profiling. The proposed reforms don't make enforcement impossible. They make unconstitutional enforcement impossible. Mobile patrol units are the most controversial aspect of ICE operations. These are roving teams that drive through immigrant communities looking for people to question. They don't need warrants. They don't need probable cause. They just need suspicion. That suspicion is almost always based on appearance. Looking Latino in a Latino neighborhood becomes grounds for stops. Speaking Spanish becomes justification for questioning. Working construction becomes reason for detention. It's profiling. And when Democrats propose eliminating mobile patrols, what they're actually eliminating is legalized racial profiling. ICE argues mobile patrols are necessary for public safety, but data doesn't support that claim. Mobile patrol operations overwhelmingly target people with no criminal history. They detain workers going to jobs. They stop parents dropping kids at school. They arrest people shopping for groceries. None of that improves public safety. It just terrorizes communities. The warrant requirement proposal is equally significant. Currently, ICE can arrest people at their homes without judicial warrants. They use something called administrative warrants, documents ICE issues to itself that have no judicial oversight. Imagine if police could write their own search warrants, if FBI agents could authorize their own arrests without judges, if any law enforcement agency could conduct operations without courts checking their authority. That would be unconstitutional. But ICE does it every day. Democratic reforms would require ICE to obtain judicial warrants before home enforcement. That means presenting evidence to a judge, showing probable cause, getting independent authorization before violating someone's Fourth Amendment rights. It's not radical reform. It's basic constitutional compliance. ICE claims this would make enforcement impossible, that judges would reject warrants, that the process would take too long, that deportable individuals would escape. But every other law enforcement agency manages warrant requirements just fine. Police get thousands of search warrants annually. FBI operates under judicial oversight constantly. The system works, unless your enforcement strategy depends on avoiding judicial scrutiny. Then, warrant requirements become obstacles. Workplace raid restrictions are the third major reform proposal. Currently, ICE can raid workplaces without criminal warrants. They claim they're investigating employers for hiring violations, but they end up detaining workers instead. Democratic proposals would prohibit workplace operations unless ICE obtains specific criminal warrants tied to employer violations. That means actually investigating businesses that exploit workers, actually prosecuting employers who violate labor laws, actually targeting the demand side of unauthorized employment, instead of just arresting the easiest targets, workers who can't fight back. ICE opposes this reform using the same argument, that it would make enforcement impossible. But what they mean is it would make convenient enforcement impossible. Raiding workplaces and mass arresting workers is easy. It generates impressive statistics. It creates fear in immigrant communities, and it requires minimal investigation. Actually investigating employers is hard. It requires evidence collection, financial analysis, complex prosecutions, and it targets politically connected business owners instead of vulnerable workers. ICE prefers easy. These reforms would require effective. Immigration applicants are panicking because they don't understand what proposed reforms actually mean for their safety. They're hearing Democrats want to restrict ICE. They're assuming that means protection. They're celebrating before anything passes. That celebration is premature and potentially dangerous. Because proposed reforms aren't enacted reforms. These bills need committee approval, floor votes, Senate passage, presidential signature, and Republican opposition to all of it. The chance these reforms become law in their current form is slim. The chance they pass with significant weakening is slightly higher. The chance ICE finds workarounds even if they pass is nearly certain. So what should applicants actually expect? First, understand that these proposals represent what Democrats want, not what will happen. The final legislation, if any passes, will be heavily compromised. Warrant requirements might include exceptions. Mobile patrol restrictions might have loopholes. Workplace raid prohibitions might be limited to specific circumstances. Second, recognize that even strong reforms take time to implement. If legislation passes tomorrow, ICE doesn't change operations immediately. They have implementation periods, training requirements, policy development timelines. During that transition, enforcement continues under current rules. Third, know that ICE will maximize enforcement before reforms take effect. If they know mobile patrols are ending, they'll conduct as many sweeps as possible now. If warrant requirements are coming, they'll execute as many warrantless operations as they can first. Reform announcements often trigger enforcement surges, not despite the reforms, because of them. Fourth, understand that legal challenges will follow any reform. ICE will sue, claiming the restrictions exceed congressional authority. Republican states will file lawsuits arguing the reforms endanger public safety. Courts will issue injunctions pausing implementation. The legal battle could last years, and during those years, enforcement continues as before. Fifth, recognize that ICE will adapt to restrictions. When warrant requirements passed for certain operations in some jurisdictions, ICE shifted to courthouse arrests that don't need warrants. When cities restricted cooperation, ICE conducted more workplace raids. When one tactic becomes limited, they find another. Enforcement agencies don't stop enforcing, they just change tactics. Immigration attorneys are advising clients to support these reforms while not relying on them for protection. Advocate for the changes. Testify about the need. Contact legislators demanding passage. But don't base your safety planning on reforms that haven't passed. Because if you assume protection is coming and it doesn't arrive, you're more vulnerable than before. The political dynamics around these reforms are brutal. Democrats propose restrictions. Republicans claim they're pro-criminal. ICE officials testify that reforms would cause chaos. Law enforcement unions oppose them. Immigration restrictionist groups mobilize against them. And immigrant families who would benefit from constitutional protections have the least political power in the debate. That's always been the problem with immigration reform. The people most affected have the least voice. Undocumented immigrants can't vote. Recent arrivals don't have political networks. Workers afraid of deportation can't publicly advocate. So reform debates become fights between politicians advocacy organizations, and enforcement agencies. The actual humans who need protection are props in other people's arguments. Some Democrats are pushing these reforms as political positioning. They know the bills won't pass, but introducing them shows voters they tried. It creates campaign talking points. It demonstrates commitment to immigrant rights without requiring actual political risk. Other Democrats genuinely want reform. They've seen enforcement abuses. They understand constitutional violations. They believe ICE operates with too much unchecked authority. They're introducing legislation they hope will become law. But both groups face the same obstacle. Republicans control enough votes to block anything, and moderate Democrats worried about looking soft on immigration won't support strong restrictions. The result is proposals that go nowhere, or proposals so watered down they change nothing. That's not cynicism. That's pattern recognition from decades of attempted immigration reform. Worker organizations are using these proposals to highlight something crucial. The reforms Democrats are proposing are normal law enforcement standards, warrant requirements, judicial oversight, constitutional compliance, prohibition of profiling. This is how police are supposed to operate, how FBI is supposed to function, how every law enforcement agency is supposed to work in a constitutional democracy. The fact that applying these basic standards to ICE is considered radical reform reveals how broken immigration enforcement has become. ICE operates like an agency above the law. They conduct warrantless searches. They stop people without probable cause. They detain individuals without judicial oversight. They operate mobile units that profile communities. None of that would be acceptable for any other agency. But for ICE, it's standard procedure. These reforms would simply require ICE to follow the Constitution. The fierce opposition to that requirement tells you everything about how enforcement currently works. Applicants with pending cases are asking whether these reforms would help them specifically. The answer depends on why they're vulnerable. If you're at risk from mobile patrol sweeps, warrant requirements would help, if they pass. If you're afraid of workplace raids, restrictions would protect you, if they're enacted. If you fear warrantless home enforcement, judicial oversight would matter, if courts uphold it. But all those protections are hypothetical until legislation becomes law. And even then, implementation determines actual impact. What you can do now is support the reforms while preparing as if they won't pass. Contact legislators. Share your story. Explain why constitutional protections matter. Create political pressure for passage. But also have emergency plans. Know your rights under current law. Understand what to do if ICE shows up. Have attorney contact information. Prepare your family for worst-case scenarios. Hope for reform. Prepare for reality. As February 2026 continues, more details will emerge about what Democrats hope these reforms will accomplish. But one thing is already clear. Knowing this right doesn't make you a criminal. It makes you smart. It means you're prepared. It means you're protecting your family. Don't assume proposed reforms mean current safety. Don't stop being careful because Democrats introduced legislation. Don't celebrate protection that doesn't exist yet. Share this video with every applicant you know. It might save their case one day. Subscribe to USA Immigration Path for more protection. We protect you with real information as the next phase unfolds.